Unit 1, Becoming a Licensed Real Estate Broker. Learning Objectives. When you have completed this unit, you will be able to accomplish the following. Explain the broker applicant requirements and situations that may cause an application to be denied. Identify the consequences of failing to disclose a previous conviction. Explain non-resident applicant requirements and mutual recognition agreements. Explain broker per-license education and experience requirements and identify exceptions to the course requirement. Identify the post-licensing and continuing education requirements for brokers. Explain active status and inactive status, and the renewal requirements for members of the U.S. Armed Forces and their spouses, and how it is unlawful to perform real estate services with an expired real estate license. Distinguish between licensure and registration. Distinguish between multiple licenses and a group license and explain the provisions for issuance of multiple licenses. Identify the rules regarding change of address, residency, and change of business address. Identify real estate services that require a real estate license and exemptions from licensure. Key terms: compensation, Florida resident, group license, involuntary inactive status, licensure, multiple licenses, mutual recognition agreements, non-resident, registration, summary of applicants, voluntary inactive status. Introduction. This unit begins with an explanation of who must be licensed and the qualifications necessary for obtaining a Florida broker license. The per-license education requirement and ways the experience requirement can be satisfied are detailed. Post-licensing and continuing education requirements also are presented, as are exemptions from the educational requirements. Finally, the unit discusses how to obtain a broker's license through mutual recognition, and contrasts real estate licensure and registration. Learning Objective. Explain the broker applicant requirements and situations that may cause an application to be denied. Licensure. Becoming a broker. Florida license law defines a broker as a person who, for another and for compensation, performs real estate services. Becoming a broker requires broker per-license education, experience, and passing the state license exam. While many sales associates want the prestige of a broker's license, they are not interested in opening their own real estate brokerage business. A broker associate is an individual who holds a broker's license, but who chooses to register and work in real estate under the direction of another broker. Sales associates and broker associates are employed by and work under the direction and control of a broker, or a registered, unlicensed owner-developer. Licensure. Application process. An individual applying for a Florida real estate license must be 18 years of age or older, have a high school diploma or its equivalent, possess a U.S. Social Security number, be honest, truthful, trustworthy, of good character, and have a good reputation for fair dealing, and be competent and qualified to make real estate transactions and conduct negotiations with safety to investors and others. A person desiring to become licensed must submit a Department of Business and Professional Regulation license application. The application is available on the internet at the DBPR's Form Center. Applicants may download, print, and mail the application, or they may apply online. The license application expires 2 years after the date the DBPR receives the appropriate signed or electronically authenticated application. You can apply for a Florida real estate license online at www.myfloridalicence.com/dbpr/. Application fees. New applicants for licensure are assessed an application fee in addition to the initial biennial license fee. Applicants for initial licensure and for subsequent license renewal also pay an unlicensed activity fee, and may be required to pay a real estate recovery fund fee, if applicable. Applicants submit the license exam fee and the fingerprint processing fee directly to the test vendor. Fee waiver for low-income applicants. The DBPR is required by Florida law to waive the initial license fee for certain low-income applicants. Eligible low-income applicants are required to pay the application fee. If applicable during the current biennial license period, low-income applicants are also charged the unlicensed activity fee and the real estate recovery fund fee. Eligibility is based on the applicant's before-tax household income. Eligible low-income applicants are required to submit an application and fingerprints, complete per-license education, and pass the state license exam. The fee waiver does not include the examination fee and the fingerprint processing fee. There are no renewal exemptions for low-income licensees. The fee waiver for low-income applicants applies to all professional licenses issued by the DBPR. Fee waiver for military personnel and their spouses. The DBPR is required by law to waive the initial licensing fee for a member of the U.S. Armed Services that has served on active duty. The fee waiver also applies to a spouse who was married to the active duty member during a period of active duty, and to a surviving spouse of a member of the U.S. Armed Services who at the time of death was serving on active duty. The fee waiver for military personnel and their spouses applies to all types of professional licenses issued by the DBPR. Eligible military personnel and their spouses must submit fingerprints and the application fee. If applicable during the current biennial license period, military personnel and their spouses are also charged the unlicensed activity fee and the real estate recovery fund fee. The fee waiver does not include the examination fee and the fingerprint processing fee. Military personnel and their spouses must also complete the per-license education requirement and pass the state license exam. U.S. Social Security Number. Proof of U.S. citizenship is not required of applicants. However, applicants must possess a U.S. Social Security Number. Florida law requires that an applicant's Social Security Number be disclosed on all professional license applications. The Social Security Number is used in determining child support obligations. License application. A U.S. Social Security Number is required to apply for a real estate license. In the full legal name section of the license application, applicants must enter their name as it appears on their Social Security card. Florida law requires that an applicant's Social Security Number be disclosed on all professional license applications. The Social Security Number is used to determine compliance with child support obligations. Reference Section 475.181, 455.213 FS, and 559.79 FS. Licensure. Reasons for denial of a license application. Some application denials result from errors made in the application process. These denials are referred to as denials without prejudice. When such errors are made, the applicant may correct or file a new application. Examples of grounds for license application denial are neglecting to answer completely all questions on the application, neglecting to forward the proper fees with the application request, and neglecting to correct errors or omissions on applications returned. Other grounds for denial are more serious and result in an applicant being denied licensure with prejudice. Examples of cause for license denial are that the applicant lacked minimum qualifications, did not possess the character required by the provisions of Florida Statutes 455 and 475, did not possess the general competence to deal with the public, or complaints against the applicant were received by the FREC or the DBPR, was guilty of acts that would have resulted in revocation or suspension of a license had the applicant already been licensed, acted in violation of any provision of FS 475.42 or was at the time subject to discipline under FS 475.25, and received assistance or cheated while taking a state license exam. Period for errors and omissions. A 30-day period is allowed after receipt of the application to check for errors and omissions and to send the applicant a notice of insufficiency concerning any additional information required. An applicant's failure to supply additional information may not be grounds for denial of a license unless the applicant was notified within the 30-day period. To check the status of your application, go to Here. Select Apply for, Update Licenses, then View Application Status. Period to inform applicant of approval or denial. Any application for licensure that is not processed within the legislated time periods must be considered approved. An applicant must be informed of approval or denial of the application within 90 days after receipt of the last correctly submitted application. When the Commission denies an application, it sends a copy of the denial to the applicant, lists the reasons for the denial, and advises that there are 21 days from the date of the order to request a hearing in accordance with Chapter 120, FS. Question number 1 of 3. U.S. citizenship is required of Florida real estate applicants. The statement is false. U.S. citizenship is not required of Florida real estate applicants. Question number 2 of 3. The DBPR has 90 days after receiving an application to check for errors and omissions and to send a notice of insufficiency concerning any additional information required. The statement is false. The DBPR has 30 days to check for errors and omissions and to send the applicant a notice of insufficiency. Question number 3 of 3. Broker applicants must possess a U.S. Social Security Number. The statement is true. Florida law requires that an applicant's Social Security Number be disclosed on all professional license applications. Learning objective. Identify the consequences of failing to disclose a previous conviction. What to disclose on the license application. Fingerprint process. Applicants must submit their fingerprints as part of the license application process. An applicant's fingerprints are scanned and electronically submitted to the Florida Department of Law Enforcement and to the Federal Bureau of Investigation. The purpose of the fingerprinting process is to determine whether an applicant has a criminal history. Applicants are encouraged to submit their fingerprints at least 5 days before submitting the license application. This allows sufficient time for the FDLE to process the fingerprints and submit the results to the DBPR. If an applicant's fingerprint results have not been received by the DBPR when the application is processed, the application will be deemed incomplete. The DBPR accepts electronic fingerprinting services offered by LiveScan device vendors that are approved by the FDLE and listed at its site. To view the vendor options and contact information on the LiveScan device vendors list, go to www.fdle.state.fl.us/criminal history records, obtaining criminal history information.aspx. Applicants can also contact Pearson VUE at https://pearson.ipfingerprint.com. For additional facts regarding the fingerprinting process and for instructions regarding how to submit fingerprint information, download and print the DBPR's electronic fingerprinting frequently asked questions at www.myfloridicnse.com/dbpr/servop/documents/fingerfaq.pdf. Question number 1 of 2. If a broker applicant's past criminal history is not discovered until after the applicant becomes a broker, the DBPR will likely take no action. The statement is false. The Commission may revoke a broker's license for failure to disclose past criminal history. Question number 2 of 2. Broker applicants are required to disclose misdemeanor offenses on the license application. The statement is true. Applicants must disclose on the license application whether they have ever been convicted or found guilty of, entered a plea of nolo contendere, or found guilty of a criminal violation, including felony, misdemeanor, and traffic offenses. Learning objective. Explain non-resident applicant requirements and mutual recognition agreements. Non-resident applicant requirements. Non-resident applicants. Florida residency is not required to possess a Florida real estate license. For application and licensing purposes, the FREC rules define a Florida resident as a person who has resided in Florida continuously for a period of 4 calendar months, or more within the preceding year, regardless of whether the person resided in a recreational vehicle, hotel, rental unit, or other temporary or permanent location. Any person who presently resides in Florida in any of the previously described accommodations with the intention of residing continuously in Florida for 4 months, or longer, beginning on the date the person established the current period of residence, is also considered a legal Florida resident. This is the test used to determine whether an applicant for licensure qualifies as a non-resident under mutual recognition. Non-resident applicant requirements. Mutual recognition. The intent of mutual recognition agreements is to recognize the education and experience of individuals licensed in another state or nation, when the other jurisdiction has education and experience requirements comparable to Florida's requirements. The agreements apply exclusively to non-residents who are licensed in other jurisdictions who received their licenses through the education and testing process of other residents in that mutual recognition state. A resident of Florida who is licensed in a mutual recognition state cannot apply for a Florida real estate license under mutual recognition. If a holder of a real estate license from a state with which Florida has a mutual recognition agreement desires a Florida real estate license, the individual submits a Florida real estate license application. The applicant requests mutual recognition on the license application and indicates from which state mutual recognition is being requested. An applicant applying for mutual recognition must obtain a certificate of license history from the Real Estate Commission in the state where the applicant is licensed. A certification of license history must contain the applicant's initial license exam information, current license status, the number of active months of licensure within the preceding 5 years, and whether any disciplinary action has been taken against the licensee. The certification is submitted with the application. Real estate applicants approved for licensure under mutual recognition are exempt from the pre-license education course. However, the mutual recognition applicant must demonstrate mastery of Florida's real estate license law by passing a written Florida-specific real estate law license exam. The exam consists of 40 questions worth 1 point each. A grade of 30 points or higher is required to pass the exam. After demonstrating knowledge of Florida license law, the applicant is issued a Florida real estate license. Individuals who receive a Florida real estate license under mutual recognition must fulfill the same post-license and continuing education requirements as all other Florida real estate licensees. Mutual recognition agreements also ensure that Florida licensees have an opportunity for licensure in mutual recognition states. The agreements are state-specific, and what is required of Florida licensees varies among mutual recognition states depending on how another state's license law compares with Florida's license law. A Florida real estate licensee interested in obtaining a license from a mutual recognition state should contact the state's Real Estate Commission for information regarding application procedures. Mutual recognition is not reciprocity. Reciprocity is an agreement between two states that allows a real estate licensee with a valid license in one of the states to obtain a real estate license in the other state. Florida does not have reciprocity with other states. Florida instead has entered into contractual agreements, called mutual recognition agreements, with some other states. Florida and another state enter into a contract to recognize each other's real estate license education. Mutual recognition applicants must demonstrate knowledge of Florida's real estate laws by passing a licensed law exam that consists of 40 questions concerning Florida-specific real estate law. After demonstrating knowledge of Florida license law, the applicant is issued a Florida real estate license. Only non-residents of Florida may use education obtained in a mutually recognized state to obtain a Florida real estate license. Question number 1 of 2. An applicant who is applying for a broker's license holds a valid broker's license in a state with which Florida has a mutual recognition agreement. The applicant is exempt from the broker per-license course but must pass the broker state license exam. Answer is false. In lieu of the broker state license exam, mutual recognition applicants must demonstrate mastery of Florida's real estate license law by passing a written Florida-specific real estate law license exam. Question number 2 of 2. A person who has resided in Florida for 3 months every winter is considered a Florida resident for licensure purposes. Answer is false. A Florida resident is a person who has resided in Florida continuously for a period of 4 calendar months or more within the preceding year. Learning objective. Explain broker per-license education and experience requirements and identify exceptions to the course requirement. Broker per-license education and experience requirements. Per-license education. Broker applicants who possess a Florida Sales Associates license must fulfill their Sales Associates post-licensing education before the expiration of the initial Sales Associates license or before applying for a broker's license. Broker candidates must successfully complete the broker course or an equivalent FREC-approved per-license course. Course 2 consists of 69 hours of instruction and 3 hours for the end-of-course examination in the fundamentals of real estate appraising, investment, financing, and brokerage operations and management. A passing score of at least 70 is required on the end-of-course exam. Students failing the end-of-course exam must wait at least 30 days from the date of the original examination to retest. Within 1 year of the original examination, a student may retest a maximum of 1 time. Otherwise, a student failing the end-of-course exam must repeat the course before being eligible to retake the end-of-course examination. Schools must administer a different form of the end-of-course exam to a student who is retaking the exam or repeating the course. Exemptions to the broker per-license course requirement. Broker applicants who have received a 4-year degree or higher in real estate from an accredited institution of higher education are exempt from the per-license education course. Although active members in good standing with the Florida Bar are exempt from the Sales Associate course, they are not exempt from the broker per-license course. Summary of education exemptions. Individuals with a 4-year or higher degree in real estate. Individuals who have obtained a 4-year or higher degree in real estate are exempt from per-license course I, per-license course 2 for brokers, and any post-license education requirements. However, individuals who have obtained a 4-year or higher degree in real estate are not exempt from continuing education requirements necessary to maintain their real estate license in Florida. Florida licensed attorneys. Florida licensed attorneys are exempt from per-license course I requirements for real estate licensing. They are not exempt from per-license course 2 or post-license education. Attorneys must still fulfill continuing education requirements as mandated by Florida law. Although exempt from FREC-approved courses I and II, must pass the license exams. Also, attorneys must be an active member of the Florida Bar. Exempts them from course I only, but must pass the license exam. Broker per-license education and experience requirements. Experience requirement. Broker applicants must fulfill an experience requirement in addition to the education requirement. A broker applicant fulfills the experience requirement by having held an active real estate license for at least 24 months during the 5-year period preceding application to become a Florida real estate broker. A broker applicant can fulfill the experience requirement in one of 3 ways. The applicant has held an active sales associate license under 1 or more real estate brokers for at least 24 months during the 5-year period preceding application to become a Florida real estate broker. The employment can be under a Florida real estate broker or a broker licensed in another state or in any foreign jurisdiction. The applicant held an active sales associate license while working as a salaried employee of a government agency and performing the duties authorized in Chapter 475, FS, for at least 24 months during the 5-year period preceding application to become a Florida real estate broker. The applicant held an active broker license in another state or in any foreign jurisdiction for at least 24 months during the 5-year period preceding application to become a Florida real estate broker. The experience cannot be earned by working for an owner-developer unless the owner-developer is a licensed broker who holds a current, valid, active real estate license. A broker applicant who holds a Florida Real Estate Sales Associate license must fulfill the 45-hour post-licensing education requirement before the initial Sales Associate license expires in order to be eligible to obtain a Florida broker license, even if the applicant is applying real estate experience from another state. If the broker applicant does not hold a Florida Real Estate Sales Associate license, the 45-hour Sales Associate post-licensing education requirement does not apply. Exam eligible. When the application processing is complete and the application has been approved, the DBPR notifies the national testing vendor. The vendor then sends a notice informing the candidate of eligibility to take the state license examination. FREC rules mandate the content of the state license examination. To the extent subject areas can reasonably be separated, 45 points are based on law, 40 points on principles and practices, and 15 points on real estate mathematics. The math questions consist of 8 points concerning the closing disclosure calculations and 7 points of general math calculations. The passing score on the state license exam is a grade of 75 or higher. Examinees' answers are graded at the test site. Examinees receive a photo-bearing exam report immediately following completion of the exam. If a broker candidate does not pass the state license exam within 2 years after the course completion date, the course completion expires and the applicant must again complete the pre-license education course. Download a copy of the candidate information booklet for the real estate broker examination at www.myfloridealicensc.com. The booklet includes important information regarding taking the state license exam. Question number 1 of 2. Broker applicants must complete at least 12 months of real estate experience during the previous 5 years working for a broker or an owner-developer. The statement is false. A broker applicant fulfills the experience requirement by having held an active real estate license for at least 24 months during the 5-year period preceding application to become a Florida real estate broker. Question number 2 of 2. A broker applicant who received a master's degree in real estate from an accredited institution is exempt from the broker pre-license education course. The statement is true. Broker applicants who have received a 4-year degree or higher in real estate from an accredited institution of higher education are exempt from the pre-license education course. Learning objective. Identify the post-licensing and continuing education requirements for brokers. Licensee education requirements. Post-licensing education. Broker licensees are required to successfully complete post-licensing education before the first renewal of their licenses. This requirement has the effect of placing all initial licenses in a conditional status because failure to complete the post-licensing education requirement will cause the initial license to become null and void by operation of law. However, in such cases, brokers may request and receive a sales associate license if they complete 14 hours of continuing education within the 6 months following expiration of the broker license and have complied with all requirements for renewal. The broker post-license course requirement is satisfied by completing 1 or more courses totaling 60 hours of 50 minutes each, including the end-of-course exam. To receive credit for the post-license course, students must earn a grade of at least 75% on the end-of-course exam. Students who fail the end-of-course exam may retest only one time using a different form of the end-of-course exam. If the student fails the alternate exam, the course becomes invalid and the student must retake the post-license course. A licensed broker who has received a 4-year degree or higher in real estate from an accredited institution of higher education is exempt from the post-license education requirement. Florida licensed attorneys who are also licensed real estate brokers must complete the post-licensing education requirement. Licensee education requirements. Hardship cases. The Commission may allow real estate licensees an additional 6-month period following the initial license expiration to complete the post-license education requirement if, due to individual physical hardship, as defined by rule, they could not complete the education requirement before the license expiration date. A physical hardship is defined as follows: a licensee's long-term illness or an illness involving a close relative or person for whom the licensee has caregiving responsibilities, the required course was not reasonably available, or the licensee had an economic or technological hardship that substantially relates to the ability to complete education requirements. An economic hardship is defined as the inability to meet reasonable basic living expenses. Licensees must request the post-license hardship extension in writing to the Commission, setting forth the basis of the alleged hardship. The Commission may request documentation to support the request. There is no legislative authority to extend the post-license requirement beyond the 6-month period. Tips regarding post-license education. Students should not enroll in a post-license course until first becoming licensed brokers. If you take your post-license course before becoming licensed, the course will not count. Students are encouraged to take their post-license education soon after becoming licensed. Do not wait until the last minute. Plan to complete the course at least 30 days before the expiration date on your license. It is wise to allow yourself ample time so that if you need to retake the exam, you can do so before the expiration date on your license. If you are taking the course by distance education, your school will need time to grade your exam and electronically submit the results to the state before your expiration date. Furthermore, you need to allow for unexpected events, such as computer problems, sickness, and emergencies. Licensee education requirements. Continuing education. After completing the post-license education requirement during the initial license period, active and inactive licensees must complete at least 14 hours of continuing education during every 2-year license period after that. 3 of the 14 hours must consist of core law, which includes updates to applicable rules and statutes. Real estate licensees must also take a 3-hour ethics course once during each license renewal period. Licensees who complete the core law course and the ethics course will receive 6 credit hours toward the 14-hour requirement, while only 3 hours of core law are required in the 2-year, 14-hour renewal cycle. The Florida legislature encourages licensees to take 3 hours of core law in each year of the renewal cycle to stay current on changes in the Florida real estate laws. A licensee who takes the 3-hour core law course in each year of the renewal period receives 3 hours of core law credit and 3 hours of specialty credit toward the 14-hour continuing education requirement. A licensee may substitute attendance at 1 legal agenda session of the FREC for 3 classroom hours of specialty continuing education credit. A licensee may substitute 3 C credits only 1 time per renewal cycle. To obtain the credit, the licensee must notify the DRE at least 7 days in advance of the licensee's intent to attend the FREC's legal agenda session. A licensee may not earn C credit for attending a legal agenda session if the licensee is a party to a disciplinary action slated for that FREC legal agenda. Active members in good standing with the Florida Bar are exempt from the continuing education requirements for real estate licensees. Question number 1 of 3. Before the first renewal of a broker license, brokers must complete 60 hours of a Florida Real Estate Commission approved broker post-license course. The statement is true. The broker post-license course requirement is satisfied by completing 1 or more courses totaling 60 hours of 50 minutes each, including the end-of-course exam. Question number 2 of 3. A real estate licensee who has attained a 4-year degree or higher in real estate from an accredited institution of higher education is exempt from the post-license education requirements. The statement is true. Individuals who have attained a 4-year degree or higher in real estate from an accredited institution of higher education are exempt from the post-license education requirements. Question number 3 of 3. A real estate broker did not complete the broker post-licensing education requirement because the broker was undergoing cancer treatment. 8 months following expiration of the broker's initial license, the licensee requested a post-license hardship extension. The Commission is authorized to grant the broker an extension to complete the post-licensing education. The statement is false. There is no legislative authority to extend the post-license requirement beyond 6 months following the initial license expiration. Broker education and experience requirement. Learning objective. Explain active status and inactive status, and the renewal requirements for members of the U.S. Armed Forces and their spouses, and how it is unlawful to perform real estate services with an expired real estate license. License renewal periods. The initial effective date of a real estate license is the date the DBPR issues the license. All real estate licenses are issued with an expiration date of either March 31st or September 30th. The expiration date assigned to a particular license is the date that will give the licensee as close to 24 months of licensure as possible, without exceeding 24 months. License law mandates that the initial license period must provide the licensee at least 18 months of licensure, but not more than 24 months. For example, assume the initial effective date of a license is July 25, 2018. The license will expire on March 31, 2020. Thereafter, every 2 years on March 31st, the real estate license expires and must be renewed. If a real estate sales associate later decides to become a broker, the effective date of the broker license will be the issue date of the broker license. The broker license may have a different expiration date than what was on the sales associate license. Assume the sales associate's license expired biennially on March 31st. Depending on the effective date of the broker license, the new broker's license may have a September 30th expiration date. License renewal periods. 90 days before the end of a license cycle, the DBPR sends a renewal notice to licensees. The DBPR either mails the notice to the licensee's last known address of record or electronically sends the notice to the licensee's email address of record. It is the responsibility of licensees to keep track of their renewal dates and license requirements. Failure to receive the notice will not excuse the licensee from completing the renewal requirements. Brokers and sales associates must complete their post-license education before the first renewal of their initial licenses. After the post-license education is satisfied and the initial license is renewed, licensees must complete 14 hours of continuing education during each renewal period. To renew a real estate license, the licensee submits a renewal notice and the biennial license fee. Real estate licensees must complete the applicable post-licensing, or continuing education requirement before renewing a license. By submitting the renewal notice to the DBPR, the licensee is attesting to having completed the education requirement. If licensees renew after the expiration date, a late fee is charged. If a licensee does not renew the license by the expiration date, the license reverts automatically to involuntary inactive status. An active licensee who fails to renew a license following expiration has 24 months in which to renew the license. A real estate licensee must not practice real estate following the expiration date of the license. It is also unlawful for a licensee holding a current inactive license to perform the services of real estate for compensation. Armed Forces Renewal Exemption. A licensee in good standing who is a member of the U.S. Armed Forces is exempt from the renewal provisions during the licensee's period of active duty, and 2 years after discharge from active duty. If the military duty is out of state, the exemption also applies to a licensed spouse, or a licensed surviving spouse provided the member of the armed forces was serving on active duty at the time of death. The Armed Forces exemption applies, provided the licensee is not engaged in any real estate activity in the private sector for profit. If a service member is actively engaged in real estate in the private sector, for profit, during active duty and for the 2 years following discharge, the service member must complete the required license renewal provisions. However, the DBPR will waive the license renewal fee. License renewal periods. Active versus inactive status. An active license is required to engage in real estate brokerage services. Licensees who choose not to engage in the real estate business may place their licenses on inactive status. There are 2 types of inactive status: voluntary inactive and involuntary inactive. Voluntary inactive. A licensee who has qualified for a real estate license, but who voluntarily chooses not to engage in the real estate business during a given period and requests such a change is placed on voluntary inactive status. A licensee cannot legally perform any real estate services for compensation while holding a voluntary inactive license. A licensee may change an active license to a voluntary inactive license status by submitting the proper form to the DBPR. Such licensees hold a current inactive license. Voluntary inactive brokers who subsequently wish to activate their licenses may do so at any time simply by completing the proper form. Voluntary inactive sales associates who wish to activate their licenses may do so by completing the proper form requesting an active license with an active broker or owner-developer. To be active, sales associates must have an employer. As with an active license, a licensee may renew a current voluntary inactive license indefinitely. Voluntary inactive licensees who satisfactorily complete the prescribed continuing education courses every 2 years must pay the appropriate fees to qualify for renewal of a voluntary inactive license. A license that is not renewed at the end of the license period reverts automatically to involuntary inactive status, except in the case of initial licenses when post-licensing education requirements have not been completed satisfactorily. Involuntary inactive. If a licensee fails to renew an active or voluntary inactive license before the expiration date, other than the first renewal, the license reverts automatically to involuntary inactive status. The licensee must complete continuing education and renew the license to either active or voluntary inactive status within the next 2 years. A license is placed in involuntary inactive status for no more than 2 years. After 2 years, the license automatically expires by operation of law without further FREC or DBPR action. 90 days before expiration of an involuntary inactive license, the DBPR notifies licensees of this upcoming deadline. Once their license becomes void, individuals who want to practice real estate again must reapply for licensure, retake Course 1, and retake and pass the license exam. Involuntary inactive licensees may activate their licenses during the 2-year period following expiration of a valid current license only after satisfactorily completing FREC prescribed courses of instruction. When licensees have been involuntary inactive for 12 months or less, they may satisfy the education requirement by completing 14 hours of FREC-approved continuing education, or more than 12 months but less than 24 months, they are required to complete 28 hours of a commission-prescribed reactivation education course. Reinstatement of a null and void license. The FREC may reinstate the license of an individual whose license has become null and void as a result of a failure to timely renew if the commission determines that the former licensee failed to comply with the statute because of illness or economic hardship. The former licensee must apply to the FREC for reinstatement within 6 months after the date that the license became null and void. Broker's license suspension or revocation. When a broker's license is suspended or revoked, no disciplinary action is taken against the sales associates and broker associates registered under that broker. However, the licensees registered under the disciplined broker cannot continue working under the penalized broker. The DBPR places the licenses of any sales associates and broker associates registered under the penalized broker on inactive status. The sales associates and broker associates are free to seek another employer and register as active under a new employer. A sales associate's license is returned to active status as soon as a new employer is chosen, and the information is filed with the DBPR. License renewal periods. Unlicensed activity. An individual may not operate as a broker without having a valid and current active license. Brokers may not employ, or continue to employ, broker associates and sales associates who do not hold valid licenses. A licensee may not practice real estate following the expiration date of the license. A broker or associate who does so, even accidentally, commits an unlawful act. Unlicensed activity includes providing real estate services for compensation without an active real estate license. An individual who operates as a broker, broker associate, or sales associate without a valid and current active license may be charged with unlicensed activity under Section 475.42 FS. If a case of unlicensed activity is prosecuted, the individual will be charged with unlicensed practice of a profession, which is a third-degree felony. Penalties for practicing without a current active license. Rule 61J2-24.001 violation. First violation, second and subsequent violations. Section 475.42 FS. Practice without a valid and current license. $250 to $2,500 administrative fine and suspension to revocation. $1,000 to $5,000. Administrative fine and suspension to revocation. Section 475.42 FS. Practicing beyond scope as a sales associate. $250 to $1,000 administrative fine and suspension to revocation. $1,000 to $5,000. Administrative fine and suspension to revocation. Section 475.42 FS. $250 to $1,000 administrative fine and suspension to revocation. Question number 1 of 3. An involuntary inactive license will expire and become null and void after 1 year. The statement is false. A license is placed in involuntary inactive status for no more than 2 years. After 2 years, the license automatically expires by operation of law without further FREC or DBPR action. Question number 2 of 3. A licensee who is a member of the U.S. Armed Forces is exempt from the renewal provisions during active duty and 24 months after discharge. The answer is true. A licensee who is a member of the U.S. Armed Forces is exempt from the renewal provisions during active duty and 24 months after discharge. Question number 3 of 3. A broker can be fined or the license suspended or revoked for hiring a sales associate who is not the holder of a valid active license. The statement is true. The penalty for a first-time offense of a broker employing a sales associate who is not the holder of a valid and current license is an administrative fine of $250 to $1,000 and license suspension to revocation. Learning objective. Distinguish between licensure and registration. Registration and licensure. Understanding the terms licensure and registration. Generally, in order to perform services of real estate for compensation, an individual must hold an active real estate license. To be licensed, an individual must demonstrate real estate knowledge and competency by providing proof of education, experience, passing a license examination, and so forth. To register, it is necessary to submit to the DBPR certain information about a person or entity so that the information can be entered into the DBPR's computer database. For example, brokerage entities are registered with the DBPR. Officers and directors of a brokerage corporation are registered with the DBPR under the brokerage entity. And sales associates and broker associates are registered under the name of the business brokerage employer. Registration is the process of submitting information to be entered into the DBPR's records. Information placed on record with the DBPR includes name and address of each licensed broker, broker associate, and sales associate, employer's name and business address for each sales associate and broker associate, license status for each sales associate and broker associate, and broker's involvement as an officer, director, or general partner of a real estate brokerage. Sales associates and broker associates licensed in Florida must be registered under their employing broker. Sales associates and broker associates may have only one registered employer at any given time. Florida licensees may also hold active licenses in other states. Registration and licensure. Registering associates under an owner-developer. An owner-developer is an unlicensed entity that sells, exchanges, or leases its own property. An example of an owner-developer is a real estate development company that owns land that it develops into subdivisions and then builds and sells homes. Owner-developers are not regulated by the DBPR. However, licensed real estate sales associates and broker associates may be employed by an owner-developer. An owner-developer's sales staff must hold active real estate licenses to be paid a commission or other compensation based on actual sales. In such cases, the name and address of the owner-developer is registered with the DBPR. Once the owner-developer information is registered into the DBPR database, sales associates and broker associates may be registered under the owner-developer. An owner-developer's sales staff is exempt from real estate licensure if paid strictly on a salaried basis. Registration and licensure. Brokerage entity registration. A broker may choose from a variety of business structures. Some brokers choose to own their business in their own name as a sole proprietorship. Others choose more structured business entities, for example, a real estate partnership or a corporation. If a broker chooses to form a business entity to broker real estate, the business entity must be registered with the DBPR. Brokers must renew the brokerage entity's registration every 2 years. Individuals who do not intend to engage actively in the real estate business include, for example, an unlicensed person who will be an officer or director of a real estate corporation. Individuals who are responsible for activities that do not require a license simply register for identification purposes with the DBPR under the brokerage entity. However, an individual who wishes to actively engage in real estate activities must be licensed and registered as active under the brokerage entity. Registration and licensure. Licensure is obtained when an applicant has met all the qualifications for practice that are specified in Florida statute and has passed the state license exam. Passing the license examination gives the applicant the right to request and be issued a real estate license. The license is a written document that serves as prima facie evidence that it is good and sufficient on its face that the licensee is duly licensed, as of the effective date shown on the license. Information indicated on the face of the license includes the licensee's full name and address, type of license number, effective date, and expiration date. The 2-letter prefix before the license number indicates the license type. BK signifies broker, SL, sales associate, and BL, broker associate. Registration and licensure. Failure to register. A licensee may be issued a citation for failing to properly register with the DBPR. 61J2-24.002. FAC. Citation authority for failure to register. Registration violations for which a citation may be issued. Fine. Sales associate operating as an associate without a registered employer due to failure to renew or properly register. $500. Broker failed to ensure that the brokerage is properly registered. Failed to ensure each officer, director, and sales associate is properly licensed. $500. Question number 1 of 3. Sales associates and broker associates may have only one registered employer at any given time. True. False. Explanation. Answer is true. Sales associates and broker associates may have only one registered employer at any given time. Question number 2 of 3. Registration and licensure are synonymous. The statement is false. Registration is the process of submitting information to the DBPR for entry into the department's records. Licensure is achieved by meeting the requirements for licensure under Chapter 475. Question number 3 of 3. A real estate license is the document issued by the DBPR that serves as evidence that the individual named on the face of the license possesses a valid license. The statement is true. The license is a written document that serves as prima facie evidence that it is good and sufficient on its face that the licensee is duly licensed, as of the effective date shown on the license. Learning objective. Distinguish between multiple licenses and a group license and explain the provisions for issuance of multiple licenses. Multiple licenses and group license. Multiple licenses. Multiple licenses are issued to a broker who qualifies as the broker for more than one business entity. A separate broker license must be obtained for each business that a person is a broker. Additional broker licenses may be issued by the DBPR when it is shown that the additional licenses are necessary, and that the licenses will not be used in a manner that is prejudicial or harmful to another person. A broker who holds more than one Florida broker license is said to hold multiple licenses. Multiple licenses allow a licensee to legally act as a broker for more than one brokerage firm. Example: Jane Doe is the broker for both Extra Fine Real Estate Services and Midnight Realty, 2 separate brokerage entities. Jane needs multiple broker licenses to qualify both brokerage entities. The Commission may deny a broker's request for multiple licenses. The practice referred to as rent-a-broker is discouraged by the Commission. The FREC holds the broker accountable for oversight and supervision of sales associates and broker associates registered under the broker. If a broker's primary broker license is disciplined, a broker who has multiple brokers' licenses may find that the FREC will take disciplinary action against all of the broker's licenses. Because sales associates and broker associates may have only one registered employer at a time, sales associates and broker associates may not hold multiple licenses. A broker licensee, therefore, may not be licensed as a broker associate for one firm and at the same time be licensed as a broker with another firm. A final order of discipline rendered against a broker for a violation of this part or section 455.227 applies to the primary license of the broker as well as any multiple licenses held by that broker at the time the final order becomes effective. Multiple licenses and group license. Group license. A group license is sometimes issued to sales associates or broker associates who are registered under an owner-developer. An owner-developer may own properties in the names of various entities. If the entities are all connected so that ownership and control is with the same individual, sales associates and broker associates employed by the owner-developer may be issued a group license. The owner-developer sends an affidavit to the DBPR with a list of all the legal company names used by the owner-developer. This allows the associate to sell for all the affiliated entities owned by the owner-developer. Owner-developers are not required to hold real estate licenses if they only sell their own properties. The owner-developer is registered with the DBPR under a pseudo number that is entered into the DBPR records. The pseudo number becomes a placeholder under which sales associates and broker associates register. To activate a sales associate license under an owner-developer, the sales associate and the developer complete the appropriate DBPR form. The sales associate's name and license number are entered on the form. The owner-developer's name, business location address, and pseudo number are entered on the form. In actual practice, the sales associate is issued a real estate license and no distinction regarding group license is made on the associate's license. Example: Joseph Jones is an owner-developer. He owns and controls 2 development companies, Happy Estates and Excellent Homes. A sales associate is employed by Jones to sell properties for both development companies. The associate is registered as active under the owner-developer's pseudo number. The associate is said to have a group license so that she can work for both Happy Estates and Excellent Homes. The licensee has one sales associate license and one employer. Question number 1 of 3. A broker associate may be issued multiple licenses. The statement is false. Because sales associates and broker associates may have only one registered employer at a time, sales associates and broker associates may not hold multiple licenses. Question number 2 of 3. A real estate broker who legally operates as the broker for more than one real estate brokerage holds multiple licenses. The statement is true. A broker who holds multiple licenses legally acts as the broker for more than one brokerage firm. Question number 3 of 3. A sales associate who is employed by an owner-developer is not registered with the DBPR. The statement is false. The name and address of the owner-developer is registered with the DBPR. Once the owner-developer information is registered into the DBPR database, sales associates and broker associates are registered under the owner-developer. Learning objective: identify the rules regarding change of address, residency, and change of business address. Change of address, residency, and business address. Current mailing address. Licensees are responsible for notifying the DBPR in writing of their current mailing address, email address, and place of practice. License law defines current mailing address as the current residential address a licensee uses to receive mail through the U.S. Postal Service. A post office box is considered an acceptable mailing address. The DBPR sends official communication to a licensee at the last known mailing address or email address, referred to by the DBPR as the address of record. Change of address. Licensees must notify the DBPR in writing within 10 days of a change in current mailing address. Licensees may mail or fax the appropriate form to the DBPR, or licensees may submit a change of address online at the DBPR online service website. The DBPR may issue a $500 citation for failure to timely notify the DBPR of the current mailing address, or a change in the current mailing address. Licensees who do not keep their address up to date with the DBPR may miss important notices. If a notice requires action on the part of the licensee's failure of timely action may lead to administrative discipline. Change of residency. A Florida real estate licensee who moves out of state and becomes a non-resident of Florida is required by law to notify the Commission within 60 days of the change in residency. The licensee agrees to keep the licensee's mailing address current. Non-resident applicants and licensees must comply with all other FS 475 requirements and FREC rules, including post-licensing and continuing education required of all Florida real estate licensees. Non-resident licensee requirements. Any resident licensee who becomes a non-resident must notify the Commission within 60 days of the change in residency and comply with all non-resident requirements. A Florida resident licensee who fails to notify the Commission of becoming a non-resident, as prescribed in Section 475.180 FS, may be issued a citation and fined $300. Reference Section 475.180 FS and 61J2-24.002 FAC. Change of business address. The DBPR must be notified within 10 days when a broker changes a business address. The purpose of timely notifying the DBPR of the change in business address is so that the DBPR database can be updated. Example: if a broker changes a business address, the new location must be registered and a fee paid. New brokerage business may not be conducted until the DBPR is notified of the new business location and it is properly registered. To avoid a gap in brokerage service, the broker can register the new brokerage office in advance. The DBPR may issue a $500 citation for failure to timely notify the DBPR of the change in business address. The most efficient way to notify the Commission of a change of address is through the DBPR's online portal. At the time of filing the change of business address notification, the broker must inform the Commission of the names of any sales associates who are no longer employed by the brokerage. The DBPR updates its database by removing sales associates who should no longer be registered under the brokerage. Sales associates who are no longer employed with the broker of record are placed on inactive status. When a broker changes business address, the licenses of the sales associates employed by the broker remain in force. Change of registered employer. If a sales associate leaves one brokerage firm and wants to work for another brokerage firm, the DBPR must be informed of the associate's new employer. Until the sales associate is registered under the new employer, the sales associate cannot work. The license ceases to be in force until the sales associate has registered under the new broker. Otherwise, the sales associate would be acting as a broker. The DBPR may issue a $500 citation for failure to notify the DBPR within 10 calendar days of the change in employers. Question number 1 of 2. A resident licensee who becomes a non-resident must notify the Commission of the change in residency within 15 days. The statement is false. A Florida real estate licensee who moves out of state and becomes a non-resident of Florida is required by law to notify the Commission within 60 days of the change in residency. Question number 2 of 2. A broker relocates her brokerage office across town. The broker must notify the DBPR of the change in business address before business can be conducted. The statement is true. When a broker opens a new brokerage office, no new brokerage business may be conducted until the DBPR is notified of the new business location and it is properly registered. Learning objective: identify real estate services that require a real estate license and exemptions from licensure. Real estate services. Florida real estate license law identifies real estate related activities called real estate services that require a Florida real estate license. Real estate services include any real estate activity involving compensation for performing the service for another. To remember: a bar sale. A. Advertise real estate services. B. Buy. A. Appraise. R. Rent or provide rental information or lists. S. Sell. A. Auction. L. Lease. A. Exchange. Real estate services are further defined in law to include the following activities in the sale, exchange, or lease of real property, including mineral rights, business enterprises, or business opportunities. Offer to, agree to, or attempt to perform real estate activities. Advertise or otherwise indicate to the public that one is in the business of performing real estate services. Direct or assist in the procurement of sellers, buyers, lessors, or lessees. Negotiate or close a real estate transaction. Anyone who performs real estate services for another person for compensation of any type must be licensed, unless specifically exempted by law. Compensation is defined as anything of value or a valuable consideration, directly or indirectly paid, promised, or expected to be paid or received. Compensation includes money in the form of a salary, bonuses, commissions, and gratuities. Compensation is also things of value, such as dinner, flowers, wine, gift certificates, event tickets, and so forth. It is a violation of license law to share a commission with or to pay a fee or other compensation to an unlicensed person for the referral of real estate business clients, prospects, or customers. However, a Florida broker may pay a referral fee to a broker licensed in another state so long as the foreign broker does not violate Florida law. Business opportunities. Chapter 475, FS, defines as real estate any interest in business enterprises or business opportunities. Because the definition of real property includes any interest in business enterprises or business opportunities, individuals who specialize in the sale of businesses, known as business brokers, must hold Florida real estate licenses. Presumption of acting as a real estate broker. If an individual performs services of real estate for another person, and a disciplinary case is filed as a result of that activity, there is a presumption that the individual is acting as a real estate licensee. Even if the individual attempts to perform a service of real estate for another person without being compensated for the service, the individual may be held liable. If an individual has sold or leased real estate that is not titled in his name, or has maintained an office bearing signs that real estate is for sale or lease, or has advertised real estate for sale or lease, there is a presumption that the individual was acting or attempting to act as a real estate broker. The burden of proof is upon the individual to show that he was not acting or attempting to act as a broker or sales associate. Unlicensed individuals may find themselves facing charges of unlicensed activity. Real estate services. Exemptions from a real estate license. Individuals may buy, sell, exchange, or lease real property for themselves. Therefore, individuals and business entities are exempt from a real estate license in the following circumstances. Property owners do not need a real estate license to buy, sell, exchange, or lease their own real estate. Corporations, partnerships, trusts, and joint ventures may buy, sell, exchange, or lease their own property. Salaried employees of these business entities may buy, sell, exchange, or lease real property for their employer, provided the activity is incidental to their employment, and they are not paid a commission or compensated on a transactional basis. A partner in a real estate partnership can receive a pro rata share of profits. For example, a 40% partner is allowed to receive 40% of the profits of the business without having a real estate license. However, if the 40% partner received more than 40% of the profits, then an active real estate license is required. Also exempt from real estate licensure are salaried employees who work in an on-site rental office in a leasing capacity and who do not receive a commission, who are managers of condominiums or cooperative apartment complexes who rent individual units for periods no longer than 1 year, and who are not paid a commission, of an owner-developer, provided they do not receive a commission, of a governmental agency who perform real estate services for the state or local government, and who do not receive commission, and of business entities who negotiate the sale or purchase of radio, television, or cable enterprises, provided the sale does not involve real property. Chapter 475 of the Florida Statutes exempts the following individuals from holding a real estate license: persons who sell cemetery lots, individuals who rent lots in a mobile home park or recreational travel park, attorneys at law when acting within the scope of their professional duties in an attorney-client relationship. In Florida, holding a Florida bar license does not entitle an attorney to compensation for performing real estate services. Certified public accountants when performing accounting duties within the scope of their professional duties. A person who has been given a power of attorney in order to sign contracts and conveyances on someone's behalf. A person cannot appoint another individual as an attorney in fact for the purpose of conducting real estate services for others. Owners of time-share periods for their own use and occupancy who later offer the time-share periods for resale. State-certified and licensed real estate appraisers who are licensed under Chapter 475, Part 2, for the purpose of conducting appraisal services. Court-appointed individuals acting within the limitations of their duties. Hotel and motel clerks who rent lodging accommodations on behalf of the establishment. Federally regulated banks and dealers registered with the Securities and Exchange Commission selling business enterprises to accredited investors. Apartment property owners or property management firms for the purpose of paying a finder's fee of not more than $50 to a tenant of the complex for a rental referral. Question number 1 of 2. A person employed by a real estate developer receives a salary plus commission for each lot the employee sells. The employee is exempt from real estate licensure. The statement is false. Because the employee receives a commission in addition to a salary, the person must hold a real estate license. Question number 2 of 2. An individual who specializes in the sale of business opportunities is exempt from a real estate license. The statement is false. Because the definition of real property includes any interest in business enterprises or business opportunities, individuals who specialize in the sale of businesses, known as business brokers, must hold Florida real estate licenses. License or exempt. If null and void, then take a 14-hour C-course within 6 months and ask to reinstate to a sales associate. To be a broker, you would need to go through the process again if your license becomes null and void. Summary of important points. A broker associate is an individual who meets the requirements of a broker, but chooses to work in real estate under the direction of another broker. Applicants must be at least 18 years old and have earned a high school diploma or its equivalent. U.S. citizenship is not required, and applicants do not have to be Florida residents. However, applicants must possess a Social Security number. The DBPR may waive the initial application, license, and unlicensed activity fees for military veterans and their spouses who apply for a DBPR license within 60 months of honorable discharge from the armed forces. A resident of Florida is a person who has resided in Florida continuously for a period of 4 calendar months or more within the preceding year. Broker applicants must complete at least 24 months of experience during the 5-year period preceding application to become a Florida licensed real estate broker. Brokers must complete 60 hours of post-license education before the expiration of their initial license. Failure to do so will cause the license to become null and void. 14 hours of continuing education each license period is required for all real estate licensees following the initial license period. A licensee in good standing who is a member of the U.S. Armed Forces is exempt from renewal provisions during the period of active duty and 24 months after discharge from active duty. There are two types of inactive status, voluntary and involuntary. A licensee who has qualified for a real estate license, but who voluntarily chooses not to engage in the real estate business may request voluntary inactive status. Involuntary inactive status occurs when a licensee fails to renew an active or voluntary inactive license before the expiration date. An owner-developer is an unlicensed entity that sells, exchanges, or leases its own property. Sales staff must hold active real estate licenses to be paid commission. The sales staff is exempt from licensure if paid strictly on a salaried basis. Multiple licenses refers to those cases in which a broker holds more than one broker's license. A group license is issued to a sales associate or a broker associate employed by an owner-developer who owns properties in the name of various entities. A group license entitles the licensee to work in the various sales projects owned by the owner-developer. Licensees must notify the DBPR in writing within 10 days of a change in mailing address. Resident licensees who move out of the state must notify the Commission within 60 days of the change in residency. Real estate services include any real estate activities involving compensation for performing the service for another. Compensation is anything of value paid or promised to be paid to an individual for performing services of real estate. Internet exercise. To answer the following questions, you will need to use the Internet. Begin by going to the Division of Real Estate website at www.myfloridlicence.com/dbpr/real estate commission divided by. At the DRE website, locate and select the link to go to Statutes and Rules. Select Florida Administrative Code Chapter 61J2 to answer the following questions. The FREC's citation authority is Rule 61J2-24.002. 1. A broker who fails to obtain a multiple permit may be issued a citation and fined what amount? 2. A licensee who fails to timely notify the DBPR of a change in current mailing address may be issued a citation and fined what amount? Unit 1 exam. Question number 1 of 15. Which activity is not one of the 8 real estate services? A. Exchange real property. B. Appraise real property. C. Finance real property. D. Auction real property. Explanation. The answer is finance real property. There are 8 real estate services that, when performed for compensation, require a real estate license: advertising real estate services, buying, appraising, providing rental lists for a fee, selling, auctioning, leasing, and exchanging real property. Financing services requires a mortgage broker license. Question number 2 of 15. A licensee who lives in Jacksonville and holds a Florida real estate license is in the process of moving to Alabama. What action must the licensee take regarding the Florida license? A. File a request for involuntary inactive status. B. Request a non-resident waiver of education requirements. C. Notify the Department of Business and Professional Regulation within 60 days of the change in residency. D. File an application for mutual recognition with Alabama. Explanation. The answer is notify the Department of Business and Professional Regulation within 60 days of the change in residency. Resident licensees who become non-residents must notify the FREC within 60 days of their change in residency. Question number 3 of 15. Which individual is not exempt from licensure under real estate license law? A. Individual serving as a personal representative and acting within the statutory limits of that designated role. B. Salaried employee of a company selling real estate owned by the company as part of the employee's normal work-related duties. C. Person selling cemetery lots for compensation. D. Person conducting an auction of real property. Explanation. The answer is a person conducting an auction of real property. Auctioning real property is one of the 8 real estate activities that require a real estate license. Question number 4 of 15. An out-of-state real estate licensee moved to Tampa Bay, Florida, 6 months ago. The out-of-state licensee has requested a Florida real estate license based on mutual recognition. The out-of-state licensee, A. Must simply register her license information with the Florida Department of Business and Professional Regulation because she moved from a mutual recognition state. B. Must complete the real estate per-license course and pass a 40-question Florida-specific real estate law exam. C. Is exempt from the real estate per-license course, however, she must pass a written Florida-specific real estate law exam. D. Must complete the real estate per-license course and pass the Florida State License exam. Question number 5 of 15. Which individual is exempt from the continuing education requirement? A. Inactive real estate licensee. B. Non-resident licensee. C. Active member of the Florida Bar. D. Individual who has received a 4-year degree in real estate. Explanation. The answer is active member of the Florida Bar. Active members in good standing with the Florida Bar are exempt from the continuing education requirement for real estate licensees. Question number 6 of 15. A broker works as an active broker for more than one real estate company. In this situation, the Department of Business and Professional Regulation will issue the broker a single broker license and require the broker to appoint an office manager at each location. B. Multiple licenses. C. A group license. D. One broker license and register the various companies as affiliated businesses. Explanation. The answer is multiple licenses. Multiple licenses are issued to brokers who qualify as the broker for more than one business entity. Question number 7 of 15. Which information does not have to be disclosed on a real estate license application? A. Ticket for failing to stop at a red light 6 months ago. B. Driving under the influence conviction that occurred 15 years ago. C. Denied licensure as an appraiser in Massachusetts. D. A plea of nolo contendere for domestic violence. Explanation. The answer is ticket for failing to stop at a red light 6 months ago. Applicants must disclose history concerning felonies, misdemeanors, and traffic offenses other than parking, speeding, inspection, or traffic signal violations. Question number 8 of 15. A person applying for a real estate broker license must a. Disclose personal financial information. B. Be a citizen of the United States. C. Disclose any denials of a real estate license in another state. D. Be a Florida resident. Explanation. The answer is disclose any denials of a real estate license in another state. When completing an application for licensure, applicants must disclose whether they have ever been denied a license, or have had a license suspended or revoked by the real estate licensing agency of another state or nation. Question number 9 of 15. Which statement best describes the legal term nolo contendere? A. It is the process of expunging the criminal record. B. It is a court decision to place a defendant on probation. C. It is a plea of no contest. D. It is an order by a court of law to stay the sentence. Explanation. The answer is it is a plea of no contest. Nolo contendere is a plea of no contest that is entered into a criminal court of law. The defendant does not admit or deny the charges. A fine or a sentence may be imposed by the court. Question number 10 of 15. Which qualification is required for licensure as a Florida broker? A. U.S. citizenship. B. U.S. Social Security number. C. 2-year college degree. D. Florida resident. Explanation. The answer is U.S. Social Security number. Broker applicants must possess a U.S. Social Security number. They do not have to be U.S. citizens or Florida residents, nor do they need to possess a 2-year college degree. Question number 11 of 15. Which statement is true regarding obtaining a real estate license through mutual recognition? A. Real estate applicants who apply for a Florida real estate license through mutual recognition are exempt from the post-license education requirement. B. Applicants applying for a Florida real estate license through mutual recognition must pass a Florida-specific real estate law license exam with a grade of at least 75%. C. States that have a mutual recognition agreement with Florida provide reciprocity to Florida licensees to conduct real estate in other states. D. Florida residents who hold a real estate license in another state may apply for a Florida real estate license through mutual recognition. Explanation. The answer is applicants applying for a Florida real estate license through mutual recognition must pass a Florida-specific real estate law license exam with a grade of at least 75%. Mutual recognition applicants must demonstrate mastery of Florida's real estate license law by passing a written Florida-specific real estate law license exam. The exam consists of 40 questions worth 1 point each. A grade of 30 points or higher is required to pass the exam. Question number 12 of 15. An employee of a real estate developer sells homes in a new subdivision. In addition to a salary, he receives a $500 bonus for each home he sells after meeting his monthly quota of home sales. Which statement applies to this situation? A. The employee is not required to hold a real estate license because he receives a salary. B. The employee must hold a real estate license because he receives compensation based on sales. C. Both the employee and his employer must be licensed real estate brokers. D. The real estate developer must be a licensed real estate broker. Explanation. The answer is the employee must hold a real estate license because he receives compensation based on sales. A real estate developer's sales staff must hold active real estate licenses if they are paid a commission or a bonus based on actual sales. Question number 13 of 15. Which statement is true regarding the pre-license end-of-course exam? A. Students who fail the end-of-course exam may retake the exam until they receive a passing score. B. If failing the end-of-course exam, the student must repeat the entire course before retesting. C. Students who fail the end-of-course exam may retest one time with a different set of exam questions within 1 year of the original exam. D. Students must pass the end-of-course exam with a grade of 75 or higher. Explanation. The answer is students who fail the end-of-course exam may retest one time with a different set of exam questions within 1 year of the original exam. Within 1 year of the original exam, a student may retest one time. Schools must administer a different form of the end-of-course exam to a student who is retaking the exam. Question number 14 of 15. A Florida broker applicant has been licensed as a salesperson in Texas from 1970 through 1995. The applicant recently moved to Florida and has completed the Florida Broker Per License course. The applicant earned a score of 76 on the end-of-course exam and has submitted the license application to the Department of Business and Professional Regulation. Which statement is true regarding this situation? A. The applicant must apply for a broker license under mutual recognition. B. The applicant has met the requirements to become a licensed broker and is qualified to take the state license exam. C. The applicant must successfully complete the Sales Associate Per License course before becoming a Florida real estate broker. D. The applicant has not fulfilled the experience requirement. Explanation. The answer is the applicant has not fulfilled the experience requirement. Applicants who have held an active real estate license in another state may apply their experience toward a Florida broker license, provided they have held an active salesperson or broker license for at least 12 months during the preceding 5-year period. Question number 15 of 15. If the post-licensing requirement is not fulfilled before the first renewal and a broker associate licensee wishes to continue in the real estate business, the licensee A. may request to receive a sales associate license, provided the licensee completes 14 hours of continuing education within 6 months following expiration of the broker license. B. is allowed 30 days to make up the post-license course but is charged a late fee. C. must retake the broker per license course within 1 year. D. must requalify for licensure. Explanation. The answer is may request to receive a sales associate license, provided the licensee completes 14 hours of continuing education within 6 months following expiration of the broker license. The license of a broker who does not complete the post-license requirement becomes null and void. However, the broker may request and receive a sales associate license by completing 14 hours of continuing education within 6 months following expiration of the broker license. This is the end of Unit 1.